The Honorable Thomas D. Salaya, Judge presiding. All persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court.
Hey, thank you. Good morning, and welcome to this session of oral argument of the 5th District Court of Appeals. It's certainly our pleasure to preside over the cases on the docket this morning. Let me introduce the panel to you. As previously indicated, I'm Judge Sawaya. To my right is Judge Griffin, and to my left, we are certainly pleased to have Judge Simone Marstiller come from Tallahassee to help us resolve the cases today. She is a district judge that sits on the 1st District Court of Appeal, and she has graciously agreed to come sit with us Tuesday and today to take care of the cases on this docket, and we are certainly pleased to have her. If you have any cell phones, electronic devices that may go off during the course of oral argument, please have them turned off so that we're not interrupted. We have a combination of criminal and civil cases. The criminal cases will be allotted 15 minutes per side. If the appellant wishes to reserve any time for rebuttal, let us know. Civil cases, 20 minutes per side. We have a clock on the podium that will assist you in keeping time, and I will certainly do everything I can to make sure the clock is performing and functioning accurately from here. So with that, we'll proceed with the cases on the docket. Let me go ahead and announce that the last case on the docket, scheduled at 10 o'clock, Derrico versus Circle K, has been continued. So if you're here on that case, you can leave. So with that, we'll go ahead and proceed with BURCH versus State of Florida.
Good morning, Your Honor.
Good morning.
Mark Taylor on behalf of Alan BURCH, and I appreciate you introducing everyone to the chambers or the court, because your name tags are wrong. And
okay. Well, that may be good for me and bad for whoever's got my name. So my condolences to that person.
Who am I today?
You're Judge Griffin this morning.
Oh, I'm Judge Griffin?
That's what, according to the name tag.
I'll take that and give my condolences to Judge Griffin.
Thank you.
Okay.
I just wanted to say a few things this morning, Your Honors. I believe that the briefs or the issues were fairly well briefed in this case, both by the state and the defendant. However, there's still a number of complicated issues that all are kind of interreacted or interrelated. We've got the constitutional issue, and we've got the entrapment issue, and the issue of the prima facie case. And in my mind, that's the strongest one, because if you look at the specific, and again, this is well briefed, if you look at this specific chat log, what was said by who and when, the government put its ad on the Craigslist webpage, and I can't emphasize enough about where they put it, under the casual encounters section on the Craigslist website. In fact, I have another case similarly situated in Polk County right now that I'm working on, and in researching that case, I had never been to the Craigslist personal site, so I did, and was amazed at some of the things that I saw on there under the casual encounters. It reads like a bathroom wall. And in fact,
just confine your argument to what's in this particular record, and not what you personally observed. So,
well, agreed, Your Honor. The point being that where it was placed is important. Is an important factor. Under what category it was placed. I believe that was the first flaw in the government's case, was placing it there, because that whole website's about sex, or that whole section, if you will. Casual encounters is just that. So I think that was the government's first flaw. The second flaw is that when Mr. BURCH responded to the ad and said, "What is it you're looking for?" because the ad seems like you're looking for a pedophile, the very next contact from the government says, "I'm not looking for a pedophile, I'm looking for a good man who can teach my daughter how to safely engage in sex." They threw it right out on the very first contact. The argument that I have, Your Honor, is that because they did that, there was no requirement that there was no necessity for Mr. Birch to lure, entice, seduce, or solicit, because the deal was already offered. The offer was already on the table without him saying anything else. And under the jury instructions, as I briefed, under the jury instructions, there has to be, the way I read them, there has to be an affirmative action by the defendant to do something, to lure, to solicit, to seduce, or entice. And our argument, I think our main and strongest argument is that he merely acquiesced. Once the government put it out there, here's the deal, you can have it. The remainder of the chats were limited to when and where. The when and where part I propose is not part of the luring, soliciting, enticing, or seducing. That's just not in furtherance of the offense. So that I think is the biggest issue, or the biggest flaw in the government's case in this specific case, was that there was they didn't afford Mr. Birch any opportunity to lure, solicit, entice, or seduce. The offer was already on the table, and all he had to do was acquiesce to it. The other issue, the constitutional issue, is problematic as well, I believe, and specifically, I tried to emphasize this in my briefs as well as I could, specifically as it goes to adult contact, third-party contact. The case law, as I said, was pretty clear that if you are speaking directly to who you think is a child, you have a higher level of scrutiny or culpability. I'm not sure of the word that I'm looking for, but if you're speaking to someone who you know or think is a child, I think it should be looked at more critically. But in the internet, in the anonymous world of the internet, when you're speaking to someone who you believe is an adult, that's where the door is open for all kinds of fantasy world and role playing, and very often I propose the person that you think you're talking to is not necessarily who they say they are on the internet, and that's problematic. Especially when the government's the person on the other end, and you click on that ad, you click on this ad, once you've inquired as to what it is, it's up to the government to decide whether or not you've now broken the law based on luring, soliciting, enticing, or seducing just by merely asking what it's about. I think that's problematic. The traveling part has its own additional component of the actual travel, but it has the same components of luring, soliciting, enticing, or seducing. So I have some concern with that. The other problem, and I know this may not pass the Snicker test, and is the innocent behavior that could come from following up on this ad. And what I mean when I say that is Mr. Birch told the undercover officers when he was arrested, I wanted to see if there was a real child, and I was going to report it to law enforcement. I've heard that from a number of instances, and it may or may not be true. I don't know. I'm not purporting that it was, but there is certainly the possibility that someone is taking it upon themselves they see something crazy on the internet, they go check it out, and once they knock on that door and are taken down, it's too late. Nobody's going to believe that. The other scenario that could involve innocent contact or innocent conduct but become criminalized is when you have a person, typically a male, who's trying to find a female, and he sees somebody crazy enough to put something like this on the internet. He wants to check it out because he thinks he may be able to have a chance with this mother, And that seems to be a fairly common theme throughout a lot of these cases. Though there never was any interest in the child, they played along with that to ingratiate themselves with the purported mother. So there certainly seems to me to be the potential for innocent conduct that can be roped in with culpable conduct, and it's solely at the police, at law enforcement's discretion as to who and when and how to charge. I think those were the main highlights I wanted to touch on. I did not want to reserve any time for rebuttal, and I'm going to stop talking. And
you don't want to reserve any time for rebuttal? Okay.
No, sir.
Okay. Thank you very much.
Thank you.
Morning, Ms. Davenport.
Good morning.
Now, you must be wondering, since we didn't ask him the first question, do we have them all reserved for you? But
That is exactly what I'm wondering.
Okay. Don't worry now. Go ahead.
Let me just say that if all that had happened here is he had said, "What are you doing with this ad?" and the mom had said, "I'm looking for somebody to instruct my daughter," and he had said, "That ain't me," he would not have committed this crime. He was going there to make sure the child was going to be okay, all of that stuff. Those are all nice things to present to a jury. He entered a plea here, and we would submit that there's clearly sufficient evidence. When you look at this entire conversation, it didn't stop. It went on, and he sold himself. He said, "Oh, I'm the man for you. I have a 13-year-old daughter myself." He did solicit this action. It is significant what the casual encounters portion of the Craigslist is, because that's where he went, and he saw a 14-year-old right there in the first ad, and he pursued it, and he's stuck with it now, and all of these arguments as to what his motives were, and it was all innocent conduct, or maybe somebody else could be innocent. Those are nice issues to present to a jury, but this is a motion to dismiss. And
suppose he had just said, "Okay."
And that would have been it?
Yeah, he said, "Okay, what time, what place?"
If she
Where
made...
would the luring, enticing, and, luring, enticing, soliciting.
I think that would be a closer call. I mean, in this case, they went back and forth. I mean, he was selling himself and encouraging that conduct. And the police officer, purported mother, said, "If you're creeped out by this, I understand. Not everybody understands my lifestyle." So, and he pursued it more, and that's when he started crossing the line. But when, this whole, it's a fantasy and things like that. You don't need condoms for a fantasy. So it clearly went well beyond just talking about this. If all he would have said was okay, I think it would have been a closer call. But he went well beyond that here.
Well, I mean, in essence, she said, "I'm looking for somebody to teach my daughter how to safely engage in sex. Let's see. I believe that to have her taught in my presence than out and about with some boy who doesn't know what he's doing is better." And he says, "If you want someone that you can use to show her, then email me back."
Right?
That's a lot like "okay" to me.
Well, I mean, she put it out there. They created the opportunity, which is perfectly acceptable. And then he said, "I can talk to her. I have a 13-year-old daughter." And if that wasn't clear enough, then he emails again and says, "I'm willing to show her too." And then, they go on from there. Again, all we have to have is a prima facie case at this level of the proceedings. He entered a plea. He didn't go to trial. And viewing all of the inferences and evidence in the light most favorable to the state, we would submit that that's sufficient. He went beyond that too. He said, "Here's where I'm available. When do you want to do this? You bring the condoms." I mean, he didn't just say, "Okay." He made arrangements to have this happen as well. So, again, some of these cases could be closer. This one, he went further than that. And he sold her to a certain extent, you know, oh, I have my own child. I'm good at this, is kind of implied in those email messages. All she did was put it out there as, here's what I'm looking for. He responded to the ad. He, you know, solicited that kind of contact. In the casual encounter section, as defense counsel
Are you
said.
suggesting that just by responding to the ad that he was luring, enticing, and
Luring, enticing, and soliciting. I think if all he had said is, are you looking for a pedophile? And she said, you know, no, or responded the way she did, that would not have been enough to satisfy the statute. But again, he went beyond that.
Okay.
And we would ask you to affirm. Thank you.
Okay, thank you both very much.